Ever think about what happens after you see those flashing blue lights in your rearview mirror?
Oh, yeah.
We all know about the breathalyzer, of course.
Yeah.
But what happens if things escalate?
Right.
What if they want to take a blood sample, you know? Like, how does that actually
Yeah.
work legally?
Yeah, that's a great question. And honestly, it can get pretty complicated legally.
Totally. It's like a whole other layer of law that most people probably don't even think about
Yeah.
until they're in that situation, right?
Exactly. And it's something we're going to dig into today. You sent over these excerpts from a Georgia Court of Appeals case, Snyder v. the state.
Oh, right. Yeah.
Yeah.
It's a DUI case, right? Like
Yeah.
someone challenging whether the blood draw was even legal?
Exactly. It's an appeal.
Hmm.
So the lower court said the evidence from the blood draw was admissible, but Snyder is appealing that decision.
Interesting. So basically what we're trying to figure out today in this deep dive is like the rules around who can actually take your blood if you're suspected of DUI in Georgia.
Right. Like, what are the qualifications? Are there any limits? And I think most importantly for our listeners is, what does all this mean if you're ever in this situation?
Totally. Okay,
Yeah.
so let's just start with the basics of this case. What happened?
Okay, so this whole thing starts back in December 2022. It was a pretty standard traffic stop. Miss Snyder was pulled over for speeding by a Georgia state trooper.
Okay, speeding happens to the best of us, so then what?
Well, then things took a turn. The trooper, he conducted some field sobriety tests,
Yeah.
and then he gave her one of those portable breath tests.
Oh, so like the ones they do roadside before they even take you in.
Right, exactly. And based on all that, the trooper arrested Miss Snyder for DUI.
Okay, so far so normal, right? Now, sadly, this kind of thing happens all the time. But there's something different about this case, right?
Yeah, so here's where it gets interesting. Miss Snyder agreed to a blood test. But the person who actually drew her blood wasn't a nurse or a lab tech or anything.
Yeah.
It was the same state trooper who had just arrested her.
Well, hold on. Really? That same trooper. But how is that allowed? Wouldn't he need some kind of medical training to draw blood?
Yeah, that's a great point, and that's exactly what makes this case so unique. Turns out this particular trooper was also a certified phlebotomist, someone trained to draw blood.
Oh, wow. Okay, so he was wearing two hats, cop and phlebotomist.
Exactly, and that's precisely what Miss Snyder's legal team is challenging. They're saying Georgia law doesn't give the arresting officer the right to also perform the blood draw, even if they have the medical training.
Okay, so this is all about how a very specific law is being interpreted then.
Right. It all comes down to OCGA section 46.392.2.
Okay, so we're diving deep into the official code of Georgia annotated now. What exactly does that section of the law say?
Well, this section specifically deals with who's authorized to withdraw blood, for testing alcohol or drug content, when it's requested by law enforcement, of course.
All right, of course.
And it basically gives a list of who can do it. A physician, a registered nurse, a lab technician, an EMT, or other qualified person. It's kind of interesting, though. It specifically says these limitations don't apply to breath or urine samples.
That is interesting. So I guess you could say the list is pretty specific then,
You could definitely say that. And that's a big part of Snyder's argument.
because it doesn't say arresting officer.
Exactly. So their argument is, since the law lists out all those other medical professionals, other qualified person shouldn't include the arresting officer. They're saying the lawmakers clearly intended to limit who could do this.
Makes sense. Like if they wanted cops to be able to draw blood, they would have just put it in the law, right?
Right. But the Georgia Court of Appeals saw it differently. They put a lot of emphasis on the plain language of the law.
Interesting.
Like, their reasoning was, if the legislature wanted to exclude cops, even those with medical qualifications, they would have specifically written that into the law.
Huh. So they're basically saying it doesn't say they can't.
Pretty much. Plus, the court made it clear that the trooper in this case was indeed a certified phlebotomist, which Snyder's legal team acknowledged. So it wasn't like he was just some random cop poking around with needles. He had the right medical skills.
Right, right. Okay, and I think you mentioned something about the Georgia Department of Public Safety having a policy about this too.
Yes. The Court of Appeals actually brought that up. Turns out the Georgia DPS policy actually allows trained law enforcement officers who are certified phlebotomists to do blood draws, as long as they meet that qualified person definition in the statute.
Interesting. So it sounds like the state agency responsible for law enforcement in Georgia is on board with this practice. Like, they don't see it as a problem.
Seems that way, at least based on their policy.
Okay, but this still feels kind of iffy to me.
Huh.
Like, can one person really be both the arresting officer, representing the law, and also the medical professional doing the blood draw?
Yeah, I get that. It does raise some questions, like, can you really separate those two roles? Is there a potential conflict of interest there?
Exactly.
It's a good question. And the Court of Appeals actually addressed it head on, but they ultimately said there's nothing in the law that prevents someone from doing both.
Oh, really?
Yeah. Their reasoning was that just because the trooper was acting as a law enforcement officer didn't mean he couldn't also act as a certified phlebotomist at the same time.
Okay, so back to that phrase, other qualified person. What did the court have to say about that?
Basically, they focused on the medical qualification itself. They said if someone has the required medical training and certification, like in this case, the phlebotomy certification, then they are an other qualified person under the law, regardless of what their main job is. So whether they're a cop, a teacher, or anything else doesn't really matter. It's about whether they can safely and properly do the medical procedure.
Gotcha. So the court wasn't looking at it as like cops versus medical professionals. It was all about whether the person had the specific skills needed.
Exactly. And they even looked at how other states have handled this.
Oh, really?
Yeah, they mentioned a case from the Idaho Supreme Court, State v. Guerra. Now, it doesn't directly apply to Georgia law, but it does show how another court interpreted a similar law. And in that case, the Idaho Supreme Court also said a cop who was a certified phlebotomist could do a legal blood draw. So it kind of backs up the Georgia court's thinking, like it's not completely out there.
Okay. But didn't Snyder's lawyers also argue that this whole thing violates the Constitution? Like, isn't there some protection against unreasonable searches and seizures?
Oh, yeah, they definitely did. They brought up the Schmerber v. California case, which is like the landmark Supreme Court case about blood draws in DUI cases.
Right, Schmerber.
Yeah.
And they were trying to say this trooper situation was unconstitutional.
Well, they focused on a specific part of Schmerber, what they call dicta, which is basically stuff the court said that wasn't essential to the actual ruling.
Okay.
And in Schmerber, the court expressed some concern about non-medical professionals doing blood draws, or blood draws happening in like non-medical settings. They implied that could be a constitutional issue.
So Snyder's argument was that even if the trooper was technically qualified, having him also be the arresting officer raises those same concerns the Supreme Court brought up in Schmerber.
Right, like, does it really matter if he's certified if the whole situation feels coercive?
Exactly.
But here's the catch, and this is really important. The Georgia Supreme Court decided not to hear the appeal based on those constitutional arguments.
Wait, really? Why not? That seems like a pretty big deal.
I know, right? But they had their reasons. The Supreme Court basically said Snyder's appeal wasn't actually challenging the constitutionality of the Georgia law itself.
Okay.
And they didn't think it required them to, like, reinterpret the Constitution in any new or unusual way. Basically, they saw the lower court's decision as just a matter of figuring out what the law meant. Statutory interpretation, not constitutional law.
Okay, so since the trooper had the medical certification, the Court of Appeals could sidestep those constitutional concerns from Schmerber.
Pretty much. They were like, look, this isn't just some cop with no medical background drawing blood. This guy had training. He followed proper procedures. They even cited a past case from the Georgia Supreme Court, Bradway v. American National Red Cross, that says phlebotomy is a medical procedure.
Okay, so big picture time. After all this legal back and forth, what are the key takeaways for our listeners?
Okay, so the big thing to remember is this. In Georgia, at least according to this Court of Appeals ruling, if a cop arrests you for DUI and they are also medically qualified to draw blood, they can totally do it legally. It's all about having that certification, not about what their day job is.
So it's not cops versus medical professionals. It's about who has the skills.
Yeah, the court's really focused on the wording of the law. Who meets the qualifications, not about excluding whole categories of people.
And even though Snyder's lawyers tried to bring up constitutional stuff, the Georgia Supreme Court decided not to touch that because the case was really about interpreting the state law, not the Constitution.
Right. Which means those bigger questions about who can draw blood and when are still out there. But they weren't relevant in this specific case because the trooper had the medical training.
Okay, so to recap, the Georgia Court of Appeals basically upheld the lower court's decision.
Yeah.
They said, no, you can't suppress the blood test results just because the trooper was the one who drew the blood.
Exactly. And the whole thing boiled down to what other qualified person actually means in Georgia's DUI law. And the courts decided it includes someone who is a certified phlebotomist, even if they also happen to be the arresting officer.
Fascinating. It really makes you think, like, even though the court said it's legal, does it sit right with you? I mean, should the person arresting you also be the one sticking you with a needle? Does that raise any red flags for you? What about just the public perception of all this? Like, how does this blurring of law enforcement and medical stuff make you feel? I don't know. It definitely gives me a lot to think about. Anyway, that's all the time we have for today. Thanks for joining us for this deep dive.
Thanks for having me.